June, Judge, even by early June 2020, there was a solidifying of leadership structure, and there was reaching out to national contacts and networking with other militias to combine forces for political violence, to basically kick off the boot, what they had been talking about since April. And so it's our contention that since April, this conspiracy was in place, and all of the statements are allowed against all of the individuals after that point. You know, by mid-June, they're actively combining with other militias, like with Adam Fox, the Michigan Patriot 3%ers. He was the Michigan contact that came from the national meeting. And Mr. Morrison has contacts with the national group even ahead of their June 6th meeting. We've got Morrison making those contacts. We have Mr. Musico referencing meeting with Adam Fox to kick off the boom, as you heard from the audio clips that we introduced into evidence. You have Mr. Bellar attending meeting in Grand Rapids at the back shack in order to represent the Wolverine Watchmen and combine forces with Adam Fox. So there's lots of discussion too, Judge, about what Mr. Fox is about. You know, there's meetings in person, there's phone calls by June, and by mid-June, the group, the Wolverine Watchmen, there's an effort to tighten the ranks and purge the people that are only the keyboard warriors, the people that are only active online and not coming to mandatory training. So the conspiracy by June, Judge, is in full swing. You know, they agreed about killing law enforcement and politicians. They just didn't agree on how exactly they were going to do it. So we're not just talking about one plan, the Governor Kidnapping plan, that we know is the ultimate result of what happens in the course of these many, many months. We're talking about by April, a desire to kick off the boog and start the Civil War. And actions are taken from then on. You know, by late June, Judge, they've collaborated on attack plans and they've combined. And by June 28th, material support occurs, training occurs at the Munich property, and all three of these individuals are in attendance, and so is Mr. Fox. And everything that happens after that June 26th date is just more material support. The training with firearms in Wisconsin, in Fowlerville for Mr. Bellar. The training hosted by Joe Morrison on August 9th. The medical expertise that's given, Mr. Morrison's advice to Mr. Fox on how to conduct OPSEC, operational security, Mr. Bellar's contribution of code words, advice on planned refinements, all of that is happening afterwards. So it's our contention, Judge, that by April onward is when this court should allow co-conspirator statements to come in against all the individuals. Does the court have any questions for me at this point? No. Okay. Thank you, Judge.
Mr. Johnson.
Yeah, and I guess you technically can't conspire to do something lawful, but it's not admissible. The April protests were lawful. They were there. They engaged in action. They violated no laws. So any alleged conspiracy to do anything at the Capitol building not only never happened, it was over. We are here for one criminal goal and one criminal goal only. And that is this alleged plot to kidnap the governor. That plot, again, and it was not even addressed by the people, were discussed in chat groups in which Mr. Musico was specifically excluded from. He was not in the leadership chat. He was not in the vetting chat. He was not in the QRF. He was not in the FAFO chat. He was not on the phone in discussion with Adam Fox. He did not pick up Adam Fox, and this goes to some of the binder arguments, so I don't want to be redundant, y'all. But if the people want to allege that there were multiple discussions about potential activity, that's fine. But those, again, will be separate and distinct alleged conspiracies, and those statements regarding those should not be imputed to Mr. Musico either. And I'd like to remind the court, there was no plan, and we got into this at the examination, and I'm sure we're going to discuss this again. There was no plan to kill law enforcement. It was a plan to kill law enforcement that killed unarmed Black Lives Matter protesters. So there was no conspiracy to kill law enforcement. And again, Mr. Musico wasn't present at that protest with the QRF. The agreement or the conspiracy to allegedly kidnap the governor occurred after Mr. Fox selected individuals that he wanted from the Wolverine Watchmen and began training in Luther, Michigan. Yeah. Thank you.
There seems to be a difference of opinion as to what the people need to prove in order to have the co-conspirator statements admitted. We are in agreement that Michigan Rules of Evidence 801 D2E governs. I do think that the Attorney General has correctly summarized the law, and certain things that I would like to note that one does not need to participate in all acts of a conspiracy. One does not even need to know who all the conspirators are. Mr. Musico would like to say that the conspiracy apparently starts when the plot to kidnap the governor crystallizes, which to some extent moves the case's timeline down the road into the second half of 2020. As the court interprets the factual proofs and the law, the three defendants were all believers in the Boogaloo. From what I've heard thus far, that means civil war. As I interpret civil war, illegal violence against the state. I don't believe that the ultimate crime needs to be crystallized at the onset of the conspiracy. There were all kinds of ideas being floated around. In fact, there was disagreement as to which state was going to go first, Virginia or Michigan. Mr. Musico himself suggested in the early months of the conspiracy, the three plan, and then sometime later, catch and release of politicians, which is basically kidnapping a politician, requiring him or her to make a statement, and then releasing the politician. The court is not indicating that merely because someone believes in the Boogaloo that they're going to commit acts of violence. This is where the circumstantial evidence comes in. Before the confidential informant ever was involved, the Wolverine Watchmen had apparently 7 training sessions and continued to have those training sessions after the confidential informant was involved. There's been a lot of discussion whether this training was offensive or defensive. I'm a lay person. And I find it incongruous to conclude that what they were doing was training to protect home and hearth. These folks were training for some type of offensive maneuver at a shooting range at Munich. Had an amazing amount of secrecy associated with their activities. Use of the encrypted service wire. And in fact, at one point in time, I believe it was late April, Mr. Musico himself told the group, if you're not willing to attack politicians, you might as well leave. And apparently a number did shortly thereafter. Mr. Musico meets with Adam Fox, who was the individual that ultimately was involved in the plot to kidnap the governor. Mr. Musico goes to the protest, one of which the protest involved him and other individuals sitting in a car. Mr. Musico makes statements. He wants to kick off the boog or boogaloo. It's determined that there's not enough people there. But all this circumstantial evidence, and I'm not even getting into all of the circumstantial evidence. There was a conspiracy to commit violence against the state. Merely because the ultimate initial tactic was not decided upon until a later date doesn't make any difference. The development of this conspiracy, I look at it as any type of large-scale project. People have multiple meetings, throw out multiple ideas, eventually agree on what they're going to do, hopefully obtain some type of consensus, and then act upon it. Under the law and under the facts, Mr. Musico, even if you accept what his attorney says, he can't go 3 days, shall I say, 3/4 of the way down the road and say, well, I was not directly involved in getting to the destination, therefore I'm not part of the conspiracy. That's not how the law reads. I think these individuals were co-conspirators, and in fact, I do believe they were co-conspirators with other groups, including Adam Fox, associated with the 3 Percenters, and with Barry Croft, who was apparently the head of the national militia. In terms of Barry Croft, phone records indicate that he was in contact, Mr. Musico, as late as September. And in fact, Mr. Musico was considered the spiritual advisor of Mr. Croft. Whether or not that's BS, ultimately that's going to be for the trier effect. So I will deny the motion, and we can proceed to bind over arguments.
Want me to get those right now, Judge?
Yes.
Be happy to.
The one thing at some point in time on the threatening to commit an act of terrorism, I would like you to address the issue of whether the act needs to be published. The statute says any person, but I wonder what your take is on whether it needs to be published to someone outside the group, because the whole idea of this threat is to scare someone. I mean, that's a non-legal way of putting it, but that's what I wondered about. Go ahead.
Thank you, Judge. Yep, I'd be happy to address that. I'll just start off, Judge, by saying that, as the court knows, here these three defendants are not charged with committing or conspiracy to commit a terroristic act. This is a whole different charge, which the court is, I'm sure, very well aware now, since you've had our briefs and you've seen the law, and they are charged with providing material support. And the court has the elements in front of it. I'm not going to go through an exhaustive list of what exactly the testimony has shown in this case, but essentially, Judge, the three individuals that we have in the courtroom were committed to political violence. Even though they didn't do it themselves, they provided material support and resources to others, intending those resources to be used in others' plans. And so they provided training while possessing firearms, personnel, and expertise, and their gang, not a typical gang like we would think of the Bloods and the Crips, but their gang, the Wolverine Watchmen, provided the means for it. And they satisfy, Judge, all of the requirements under Michigan law. The 5 things that are needed are satisfied to consider the Wolverine Watchmen a gang in Michigan. And we're talking about a group of people here who not only believe in a certain ideology, the Lugu, as the court's mentioned, but they advocate for it, they recruited for it, they trained for it, and they attempted to combine with other groups to commit it. So these are not your keyboard warriors here, Judge, that do nothing but sit in a room and type. These are people who are engaged in multiple real life activities to, as the statute says, to plan, to prepare, to carry out, or to avoid prosecution for. So they're using, this gang, Judge, used extensive secrecy techniques, as the court has noted. They trained on offensive military tactics, and in some cases were better outfitted than our own military. They were not sophisticated plans, but if the Capitol insurrection that occurred in January is any indication, Judge, you don't have to be organized. You just have to be filled with rage and lack impulse control. And that's what these individuals were doing. They didn't go out and participate in a plan to kidnap the governor, but their group provided the motive, means, and opportunity for those individuals that did to do so. With not only these 3 individuals' knowledge, but with their consent and their encouragement. When they communicated those plans to commit violence, those threats of terrorism to other persons, that satisfies the communicating a threat of terrorism charge, Judge. Even if they didn't mean it, even if they didn't intend to carry it out, even if they couldn't carry it out, this is all built into the statute, even if they changed their minds later, because the charges cover true or false threats, and buyer's remorse isn't a defense in this case. Now, when the court asks the question about who does this have to be communicated to, the statute is very clear, and it says that the threats have to be communicated to any person. Communicated, not published, Your Honor, but communicated to any other person. And these threats were communicated in a variety of ways. not only digitally, but in person, over the phone, all different ways, Judge. And so the statute requires communicating. Now, there's one case in Michigan law that really picks apart what it means to communicate a threat of terrorism, how you do that, and basically is the law in Michigan as it stands on communicating with terroristic threats. The name of the case is Ostentowski. I'm sorry, I know I'm butchering how that is pronounced, Judge. But in that case, there was an individual who was communicating online. It was an individual in Macomb County in Michigan who was communicating online with a girl, and I believe she was in Washington State or Seattle area. And he was telling her about how he wanted to do violence at a school shooting type of threat. And she didn't know if he was serious or not, but he did quite a bit of communicating. She was located all the way in another state. And the court in that case, one, upheld the statute when it applied sort of First Amendment scrutiny to it, Judge, and found that it could uphold the statute because it was looking to protect a very serious interest of the state. And on top of that, Judge, that threat was communicated online. It was never in person, and it was to a person all the way in another state. And so the law in Michigan does not require that it is outside of what the court might consider a closed group. This threat is communicated to any other person, and that's what satisfies the statute. Am I addressing the court's concern? Is there anything additional you wanted to ask about that?
You want to focus in on any person.
Mm-hmm.
The issue is the case law seems to cite, and I was looking for it, I got some
Mm-hmm.
papers here. Let's put it in my words because I'm a fairly simple guy. But those threats need to be made with the intent to commit mayhem or cause, shall we say, dysfunction within the state. And let's get away from the digital stuff, which I think the public digital stuff is covered by the First Amendment. Let's just talk about the words. All of the words that these three defendants purportedly made were to other watchmen and the confidential informant. They would have had no intent at that point in time to commit mayhem because they would have perceived all of the individuals that they were communicating with would not say a word about it because they were trying to keep it secret. That's the issue I'm having. I understand what any person means, but can you identify any person that received any purported threats outside the closed group of the watchmen or the closed group of the various co-conspirators? That's the issue I'm having with your position.
Sure, Judge. And here's the thing, not only were these statements about the plans for violence within the closed group, but many of these statements were communicated on wire to other people that are not seated in the courtroom in these groups where they would have the Wolverine Watchmen main chat, they would have these various chats. Some of these statements were made over that communication means
But
as well as posted on Facebook, Judge, publicly.
All these statements made by these defendants, if they made them, they're preaching to the choir. They're going to keep it secret. I'm not seeing where there's an intent to commit, and once again, this statute doesn't say it, but intent to commit mayhem.
But that's what the statute doesn't say, Judge. It
Well,
says
no,
that
the case law. What I'm saying is the case law says it.
Sure, but I don't think the case law says that it requires an intent to commit mayhem. I believe that the case law says that you have to threaten to commit an act to any other person, and that you have to knowingly make it, you have to make that threat and know it's either false or true. And it doesn't require any closed group or outside of a closed group. It doesn't require any sort of, the law at least does not require that it be made outside of people that agree with you. That is not part of the law. The person is guilty of making the threat if the person does the act, Judge, with specific intent. And that's the thing.
Specific intent to do what?
Just to communicate. The specific intent is to communicate the threat, Judge. That's what the specific intent relates to.
So as far as the statute goes, if someone makes a threat to a 1-year-old, that satisfies the statute?
Well, Judge, it requires that it's a serious threat, right? A
Okay.
true threat under a First Amendment analysis, which is
Well, once
a
again-
serious threat and an intent to commit, a serious threat for an intent to commit an act.
Okay, well, using your definition of a true threat. You
It's
make
not
a
my
threat.
definition, Judge, it's the court.
The court's definition of a true threat
Yes.
to a 1-year-old. You think that satisfies the statute?
Judge, I wouldn't say that that would satisfy the statute.
Why not? It's
Because you're
any
not
person.
really communicating to a 1-year-old a threat, a serious threat. You can't communicate a
It says any
serious threat.
person. Aren't you adding some interpretation then to the statute?
No,
It's not
Judge, I'm actually sticking I'm sticking quite to the statute in the sense that it requires a serious threat, right? And it requires that it be able to be communicated. In the case of Ostenkowski, Judge, he communicated to a girl that was not even in the state. Digitally.
But when you say stuff like that to someone out of state, it's quite clear in that scenario, she's going to tell someone.
Sure, Judge, and in this case, all of these threats were communicated to the CI, who is not part of the conspiracy. A CI cannot be a part of the conspiracy. And so if Dan, who came in and testified that he was in fact concerned about these threats, if he was concerned about these threats, then that satisfies the statute in and of itself. They've communicated it at least to him.
I think we'll probably hear from Mr. Kirkpatrick.
I'm sure we will.
Okay, go
I'm
ahead.
sure we will. I think, Judge, I just want to highlight to the court a couple of things real quick, then I'll sit down. Sorry, just one second.
okay.
Judge. But you know what, I'm just gonna save my time here, and I'm gonna let Mr. Kirkpatrick talk and all the other attorneys talk, and I'll come back, and I'm sure I'll have more to say.
Okay.
Thank you.
Good morning, Your Honor. Andrew Kirkpatrick on behalf of Mr. Bellar. Your Honor, I'm going to start with just my argument for the first part of the bind over. As the court's aware, Mr. Bellar was initially charged in this case with materially supporting a terrorist act, being a member of a gang, committing a felony, and felony firearm. I guess I'm being a little premature because the prosecutor hasn't actually asked for a bind over on my client for making a terrorist threat. However, based upon my conversations, I believe that's coming. So I'm just going to address it initially, and I will get to my interpretation of the case law as it pertains to a threat being made to any person, because I disagree with the prosecutor's argument there. But I'll get to that after I go through the rest of my argument, Your Honor.
I'm going to briefly interrupt you. Am I correct in assuming that the Attorney General wants a bind over as charged, and you want the additional charge of?
Communicating a terroristic threat on Mr. Bellar, yes, Judge.
Okay, go ahead.
And I was made aware that that's why I actually put it in my memorandum as well, Your Honor, regarding the request that the court deny the bind over. Your Honor, the court sat through this 3-day hearing and heard the testimony in this case. And what we have here, in my opinion, based upon how I see the facts, is the Wolverine Watchmen group. They develop a militia, which, as the court's well aware, especially in the state of Michigan, is not illegal. It's not illegal to be a member of a militia. Otherwise, we would have numerous individuals in the state of Michigan that would be arrested right now for merely being a member of the militia. My client, Mr. Bellar, gets involved in this Wolverine Watchmen. And what is part of the training? Part of the training is, yes, and I think the facts are undisputed, for a potential civil war. Now, where I disagree with the people as it pertains to my client, Mr. Bellar, is that I don't think my client got involved in this because he wanted to go on the offensive and go out and attack individuals, attack law enforcement, attack politicians. He got into this because, quite frankly, and again, I am not going political in this argument, Your Honor, but in the beginning, I have to say a couple things. 2020 has been like no other. I'm 51 years old. I never in my life thought that I would be concerned about civil unrest in this country as I am today. When you look at what was going on during this time period, you look at what's going on in Portland, we've got nightly riots, federal buildings being burned. You look at what went on in Seattle, we've got an entire metropolitan area blocked off by individuals, a police department, an entire precinct in a major metropolitan area abandons itself. And the government was doing nothing. So people were concerned, Your Honor. People were concerned. They're concerned about what may happen in their home, what may happen in their hometown, what may happen where they are. So there was training. I don't dispute that. And they were training. Here's the concern. The people want to say that when they were training for terrorist acts. And one of the biggest things that they talk about up front is this storming of the Capitol. Well, the court heard the testimony, Your Honor. There was never any storming of the Capitol. There was never any attempt to storm the Capitol. There was a couple individuals making some ridiculous talk, which went absolutely nowhere. And what did happen, Your Honor? They walked up the Capitol steps, armed. The prosecutor points out they had on their gear, they had their weapons, they had their attire, none of which is illegal. You can take a firearm into the state capitol. What else do? They go through the front door of the state capitol. They answer all the required questions for COVID-19. They allow for their temperature to be taken. They enter in peacefully. Now, while inside the Capitol, there are individuals that are yelling at law enforcement, and quite frankly, there was a significant presence of law enforcement on that incident at the Capitol. What does my client do? He leans up against the wall, does nothing. Then there's testimony from the informant while they're in the Capitol that they banged on some door that they thought the governor was behind, somehow implying that they were trying to breach this door. Your Honor, that's not facts and evidence. They banged on a door, again, not illegal. And in fact, I think it's common knowledge for anybody to know if an individual goes into the state capitol and commits a crime with the amount of MSP present that day, they would have been arrested. Even the FBI agent testified that they had broken no laws to where they could be arrested, and nor did they intervene. Again, we have FBI that's watching this group throughout, and at no time under any of the protests did they ever have to intervene. At no time during any of these protests was Mr. Bellar ever arrested, let alone contacted by law enforcement for any wrongdoing. They talk about the Black Lives Matter protest that Mr. Bellar went to in this QRF, as if this QRF is some separate group of the Michigan Watchmen, the Wolverine Watchmen. And at this Black Lives Matter, that there's this terrorist act that takes place and or potentially takes place. And Your Honor, this is where we get into the conversation about the harming of law enforcement. Brother counsel hit the nail on the head with his argument under the co-conspiracy, that there was never a threat. We are just going to willy-nilly, out of nowhere, go out and just kill law enforcement for the fun of it. That never took place. What was the testimony? The testimony was, by the own informant, that Mr. Bellar's purpose of going to this Black Lives Matter protest was to protect the protesters. And that if, condition precedent, if law enforcement did something to where he had to protect their lives, he would do so. Now, should he have done that? No. Should he have put himself in a position where he may have had to engage in what he believed to be improper misconduct by law enforcement? No. But again, we're not here for that. We're here whether it was illegal. It was not illegal. What he did at that Black Lives Matter protest was not illegal and not an act of terrorism. So we talk about the training, and one of the things the prosecutor keeps driving home is this material support, that Mr. Bellar somehow materially supported this ultimate group that went on to plan to kidnap and abduct the governor of the state of Michigan. Well, you heard the testimony, Your Honor. At these trainings, Dan, the informant, is the one that actually did the tactical training for the most part. He testified. He read right off of the training plan that the people presented as an exhibit when it talked about tactics and ambush tactics. And I'm paraphrasing here, Your Honor, but something to the extent of Dan's going to have to handle that because I don't know, pardon my language, shit about that, laughing my ass off. It's Dan. Then the people want the court to believe that my client at these training sessions provided basic first aid, which ultimately materially supported this plot and plan to kidnap the governor. And because he trained this basic first aid, that he is somehow materially supporting this ultimate plot to kidnap the governor. Well, we know that's not true, Your Honor, because later on we find out that the actual group that made the plan to kidnap the governor had a medic, Mr. Molitor, hand-selected by Adam Fox, who my client didn't train. And what was the other testimony? My client's experience in medical is being an explorer in high school for the Brightwood Fire Department. That takes me back to the tactics, Your Honor. Prosecuting attorney, they must be saying that the material support here is the tactics and the medical training, because we know he didn't support him financially. He didn't have any money. We know he didn't supply him with supplies. And they talk about these code words, as somehow he came up with these code words at a later meeting after he had left the Wolverine Watchmen. There's been no evidence presented to this court that those code words were ever used and or implemented by this ultimate plan by Adam Fox and his other individuals to commit this terrorist plot. His training. What was the testimony for his training? He didn't even make it through full basic training. He made it through Army boot camp and failed to make it through AIT. He didn't even make it into the Army. What is the group that we have that ultimately plans to kidnap the governor? What was the testimony on that, Your Honor? It was this. We have Adam Fox, who is a high-ranking member in the 3 Percenters, been in militias for years, fully trained. We have a Navy SEAL, the most prominent, the most well-equipped and well-trained units that the United States military has to offer. We have a U.S. Marine. We have an Army vet with combat experience, who is the informant.
I guess, should we take all of that stuff at face value? We can't take what your client says at face value.
I'm sorry, as far as what, Your Honor?
Well, you're saying how skilled these other people are. All I'm saying is your client certainly misrepresented himself very extensively to the Wolverine Watchmen. So,
yeah, because he found himself in a situation where he was around a bunch of individuals who were talking a bunch of stuff, and he got involved in the conversation, and he made a stupid mistake, but not criminal. The end of June, well, strike that. I think the evidence is clear that Adam Fox is the individual that comes up with this plan to kidnap the governor. It's throughout the testimony. What does my client say about Adam Fox? In June, he's crazy. How does Adam Fox even get into the Wolverine Watchmen, the FBI? The informant, the court heard a 20-minute phone conversation that was in evidence with the FBI informant, with the FBI right next to him, inviting Adam Fox to the Wolverine Watchmen. My client tells the informant on more than one occasion that Mr. Fox is crazy. There's a training in June. There is the Wisconsin training that my client goes to, and the only reason he can go to that training is because the informant pays for everything to allow him to go. But the testimony is clear. There was a falling out with Mr. Bellar in the end of June where he was leaving the Watchmen. And then in July 29th or thereabouts, my client tells everyone, I'm leaving. I'm going to live with my father. I'm going to get a job, which he did at DoorDash. I'm going to go back to school so I can become an EMT and become a firefighter. He's gone. He never comes back to the state of Michigan. And I think the record is clear that this whole plan to kidnap the governor didn't start until the first part of August. And my client is gone now. My client was not part of any meetings. And the other thing, Your Honor, when they first talked about kidnapping the governor, it wasn't kidnapping the governor. It was trying to get a sheriff and a judge to do an arrest order to arrest the governor, to charge her with a crime based upon the shutdowns and the lockdowns and all those things. That was the initial conversation regarding the governor. So Mr. Somberg brought up a statement during this case, and it talked about an idea and a plan. And I think that the idea and the plan plays a lot in this case, because just saying something, and I'm going to get to the terrorist threat argument here in just a minute, Your Honor. Just saying something is not sufficient for material support. In the beginning, there were all these little ideas thrown around. Not by my client. My client stupidly said, I'm down for anything, and hung around, but he figured it out. He figured it out in short order. As soon as Adam Fox got involved in this case, he figured out very quickly that I need to leave, and within 6 weeks, he was gone, never to return. And that was undisputed testimony, even from the informant. He was gone. Mr. Bellar did not provide any training on surveillance, did not provide any training on water maneuvers, did not provide any training, specific training regarding any layouts of the Capitol, any layouts of the governor's house, any plans of how to enter into the house. He didn't do any surveillance or engage in any surveillance up north where they were checking out law enforcement locations and response times and bridges and all this other stuff. There's no training that Mr. Bellar provided to this group that materially supported them in any way. Regarding the threats, I agree with the court. Well, first, I agree that the statute is vague when it says any person. And I, too, reviewed the case of People v. Ostentowski, which is cited at 274 Mishap 593. And the one thing that the prosecutor has skimmed over is on page
109.
Page 602 of the opinion. The court actually defines true threats. And it says, true threats encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. And they were citing Virginia v. Black, which is a U.S. Supreme Court opinion, cited at 538 U.S. 343. The speaker need not actually intend to carry out the threat. Rather, a prohibition on threats protects individuals from the fear of violence and from the disruption that fear engenders, in addition to protecting people from the possibility that the threatened violence will occur. I agree with the court. Just because you make a statement to an individual doesn't rise to the level of a true threat. I apologize. I'm not saying the court made that ruling. I didn't mean to put words in the court's mouth. This case is distinguishable significantly from the case at bar. And here's why it's distinguishable, for a couple of reasons. Number one, this threat was very in-depth on planning and how something was going to occur. And it was made to a person not part of the design plan as we have here. I agree with the court 100%, and I put it in my memorandum. What we have in the case at bar is a group who has an encrypted private chat room and private text messaging. Nothing was presented to anyone other than individuals within this group, and therefore it fails because it doesn't meet the true purpose of the prohibition of a true threat, and that is to protect individuals from fear of violence or from the disruption that fear engenders. If nobody knows about these threats, if no one's made aware, they didn't call the Capitol and say, we're going to storm your place at 1 o'clock today. They didn't call the governor's office and say, we're going to bomb your building. They did not say these statements to anyone. It was within the own group. It's also distinguishable because when Mr. Osentowski sends these threats to another individual who's not part of their group, she then prints and gives those to her father, who is a police officer, who then gives those to Clinton Township Police Department, who then obviously takes action. So those threats actually did bring fear. They brought fear to the listener or to the individual person who was not of the same mindset of the defendant in that case. And then they further brought fear to the school. And what did they do? They did a search warrant. They went to the house. They found pipe bombs. They found firearms. They found all these other things. So that case is completely and totally distinguishable from this case. Because in this case, there's no proof, no facts and evidence that anyone was ever made aware of these threats. And oh, the prosecutor's grasping at straws. Well, we had the informant in there. The FBI put this informant in there, and he's part of this group, so that's the person that they made it to. Seriously? Your Honor, I'm asking the court to deny the bind over as it pertains to Mr. Bellar.
Thank you.
There is no material support shown here, none. Without the material support, there is no felony. I'm not even going to get into the arguments of whether there's a gang or not, because quite frankly, I don't think I need to make that argument, because I think the prosecutors failed to show that there's material support for any terrorist act as it pertains to Mr. Bellar, my client. Therefore, there is no actively involved in a gang, committing a felony. There is no felony firearm. And based upon the arguments that I just set forth, Your Honor, the anticipated request for a bind over that my client made terrorist threats, I would also ask that the court deny the bind over as well. And I would ask the court had these questions of me.
Okay, thank you.
Thank you, Your Honor.
Mr. Somber?
Thank you, Your Honor. First, I haven't heard a specific bind over argument on the record against my client. Is it all four charges?
Yep, that's
I
correct.
clarified that when we got started. When we got started, I said, are you moving to bind over all defendants with the added charge against Mr. Bellar?
Okay, thank you, Your Honor. I actually going to start with addressing the gang argument first, Your Honor. MCL at 750.411U clearly exempts nonprofit organizations, Your Honor. There is clear testimony that there was no profit being made whatsoever. There's nothing being sold, no fundraising, no dues. The group had no income. The group had no money going to any sort of leadership, Your Honor. In the Attorney General's brief, they just leave that little part. They put a ... where it says other than a nonprofit organization, Your Honor. So I think on its face that they're not a gang at all. The statute itself being very overbroad, if it didn't include that, any sort of organization, any sort of hunting club, sports club would be a gang, Your Honor. But there's no test. There's testimony that no one was making any money. They were not for profit. There's no requirement in the statute. You have to take a statute at its face. There's no requirement that they file paperwork for the government to become an official tax exempt organization. All it says is other than a nonprofit organization, they were not for profit, Your Honor. The next charge I'd like to address for Mr. Morrison is the felony firearm. The only evidence in our 3 days of Mr. Morrison ever possessing a firearm was at the Capitol at the protest. And that's where the pictures were showed. There's testimony that he was walking around with firearms. Other than that, Your Honor, they have the Attorney General has the burden of showing that the person possessed a firearm during the commission of whatever felony, during the commission of. So if he carried a gun at the Capitol while he was protesting, well, so what?
Well, if the repetitive training, live fire tactics constitute material support, isn't that enough to legitimize a felony firearm charge?
Well, Your Honor, and keyword searches Morrison and the entire transcript. There's testimony that Morrison was posted trainings, that he was at trainings. There's nothing that says he ever possessed a gun and fired a gun. So even if
aren't there, it seems like I read a section where they all carried long guns.
at the protest.
I mean, the record speaks for itself, but I mean.
I would, the carrying of the gun, of the firearm, the possession of the firearm needs to be done during the commission of the felony. So even if they're walking around Joe's property and he has a rifle slung over his shoulder, is in that moment, is he in the commission of an otherwise felony, Your Honor? I would argue no. Next charge to making a terrorist threat. I would echo the case law that Mr. Kirkpatrick stated in Ostentowski, where true threat means to come as those statements or means to communicate a serious expression of intent to commit an act of unlawful violence. So communicating a serious threat of expression of intent, you can't do that within your own group. That doesn't make any sense. That's not a communication. That's just talking amongst yourselves. There has to be a true threat. A threat meaning has to be threatening. Somebody has to be scared, threatened, and further, in people in Ostentowski, the people also have the burden to show that these words are not mere hyperbole, Your Honor. Hyperbole being exaggerated statements or claims not to be taken literally. So you're allowed to say bad things. You're allowed to express your anger. You're allowed to swear, to curse, to say all sorts of things, which was also a lot of the climate in 2020 from many people across all political spectrums. I feel they failed to show that what he said was not mere hyperbole, and I would follow up just that it was that anything that Mr. Morrison say, they're arguing to use a lot of theys. They said this, they said that, and I haven't seen any specific statement that Mr. Morrison said to anybody outside of his own group that was a true threat, a serious threat. I didn't see any evidence of that, Your Honor. Going up now to the providing material support to a terrorist, Your Honor. I guess I'm trying to make a defense and an argument. It's like, okay, well, first of all, who's the terrorist? What was the plan? And from everything we talked about the last 3 days, like, I guess we're talking about Adam Fox. So we're not talking about Mr. Musico, or are we? It was a little confusing, but Mr. Musico, I mean, they live together. So he can't provide land or space that is already provided. He lives there. So we're talking about Adam Fox. Well, what was the support provided to Adam Fox. And that's support, but material support. So if somebody, we talked about ideas and plans. If someone says, well, we should kidnap the governor, you say, yeah, go for it, cool. That's not material, even though you're expressing, I agree, is not material. Saying go for it is not material. Saying I'm down is not material. So we're at exam, very low standard here. Is there a question of fact to the jury? So if we even take the testimony as fact that Joe Morrison said, yes, I'm down, when the confidential informant said, are you going to kidnap the governor with me or what? That's not material support. And after that evening, which was after a training, Joe never trained with Adam ever after that. And in fact, I have a start highlighted here at April 4th. The confidential informant said that to the FBI that Adam Fox told him that Joe Morrison was not yet aware of the conspiracy or plan to kidnap the governor. No money was provided by Joe Morrison to Adam Fox or anyone. No ammunition, no training. It's Joe's land, but he didn't provide any training. That was the FBI. No direction was provided by Joe. Joe didn't provide any person or tell anybody, hey, you go and be a part of Adam's plan. In fact, the entire group, he was kicked out of his own, everyone left the Wolverine Watchmen groups. Many more group chats were created on multiple platforms, which he was excluded from. And the group was mad at him at the time for just being gone and disappearing. So again, what is the material support to the plan? And not only does it have to be material support, but you have to know that that material support would be used to carry out, facilitate, avoid apprehension, create a plan. So even if Adam Fox was at, we had 3 days of testimony, but I was really, how many days does it take to establish? You just need one screenshot, you just need one conversation where my client says, yeah, Adam, come to my house and train to kidnap the governor. Just one text message saying, okay, let's meet at my house and we can plot tonight. I mean, there's just nothing there. And the support has to be in furtherance of, the material support has to be used to carry out the plan. So if you have, Osama bin Laden over for dinner before 9/11, and you tell him, yeah, go ahead, I agree with your plan. And maybe the people say, well, you provided them food. You gave them nourishment. So you provided them food, and that's material support. I'm trying to think of an analogy, Your Honor. Whatever Joe Morrison is alleged to provide materially, which I would argue is nothing at all, but that whatever would be provided also to be in furtherance of whatever alleged plan, and there wasn't even a plan at the time. When I cross-examined, it was which witness this was actually to Dan. June 29th, Joe Morrison's out of the loop. That was placed into evidence. On 8/4, Joe Morrison not yet aware of any conspiracy. 8/20, confidential informant hasn't heard from Joe Morrison. Fox says he's not involved. 8/26, this is when everyone starts leaving the Wolverine Watchmen Facebook group. 8/27, the next day is where Joe reaches out, or there's a conversation between Joe and Adam Fox, and Adam Fox says, hey, there's always room in my table. That was placed in evidence, meaning Joe's not at his table. (9/17), Joe statements in evidence. Joe never shows up. Also on 9/17, we've separated from Joe. 9/28, between Adam Fox and the confidential informant, this was in evidence. Adam Fox says, where have they been since the beginning? Talking about Mr. Musico and Mr. Morrison. Confidential informant in that conversation says, yes, they're MIA. So, Your Honor, even if the light most favorable to the Attorney General here, Your Honor, they provided no evidence. There is no question of fact for the jury to decide here. Your Honor, even if we say everything you said is a fact, it doesn't meet it does not meet any of the charges of which Mr. Morrison is charged. For those reasons, we ask you to deny their motion for binding.
Thank you.
Yeah, I'm gonna try my best not to be repetitive. I know we've had various arguments. Now, first, I think there may be a no model jury instruction for the material support of terrorism. So I took the liberty of drafting my own, if I can approach the court.
Sure.
Your Honor, we are objecting to the bind over of all counts of Mr. Musico. Your Honor, the testimony presented that around November, the Wolverine Watchmen formed. It's formed as a Facebook group, had 2 administrators. They were looking for like-minded individuals to train. People are alleging that makes them a gang. The Wolverine Watchmen are a gang. Local bar association would be a gang. Black Lives Matter would be a gang. NAACP would be a gang. Any religious group that had a Facebook page would be a gang. They were or believed in the Boogaloo, an impending of belief that there may be, at some future point, a civil war. It's not a conspiracy, just a shared belief that social groups often have. Mr. Musico was not an administrator of his Facebook page. He was not an administrator of the private chats. There was testimony that there was recruitment and vetting. Over the course of the cross-examination, specifically asked, who did Mr. Musico recruit or vet? The answer was always either I don't know or in the negative. There were 7 trainings that were planned prior to any shutdown order or any COVID-19 action taken by the governor. And at some point, Dan joins the group. Now, Dan then goes, because he has a disagreement with the group, contacts law enforcement, who then contact the FBI. He's inserted back into the group as a confidential resource. There's protests that are attended, and you saw from the slide presented by the people, most of these actions taken by the Wolverine Watchmen, what I'm gonna call the Wolverine Watchmen, were lawful, all of them. You had the Operation Gridlock protest, as council stated, was a protest. They were there exercising their First Amendment rights. It was known that they were going to be there. The media showed up. Law enforcement was there. It was training in April. A second protest while House was in session. And the people made a big issue about that protest, but as Mr. Kirkpatrick stated, that again was a planned protest. They showed up and exercising the First Amendment rights. They were allowed into the building. They checked in with the police. They had on their masks. They had the temperature taken. They were given instructions on what to do and what not to do with their weapons. They were allowed in the building. To compare that to what happened on January 6th at the federal Capitol is highly improper. What happened here in Michigan with the Wolverine Watchmen is how it's supposed to happen. You have a protest. You stay in the publicly accessible areas of the Capitol. You comply with law enforcement. You express your grievances. Yes, you yell and scream. That's the point of a protest. Your Honor, this is the United States of America. We talk disrespectful to each other. That's what we do. We yell at our law enforcement. We say mean things about our elected officials. That's what sets us apart from most countries that don't have our First Amendment protections.
Does your client actually believe that the Attorney General is saying that the public protests that anything was done wrong?
We hope not, Your Honor, but they admit into evidence things from that public protest.
But can't legitimate lawful actions be utilized to help glean intent if someone does an act down the road, which arguably could be criminal?
I don't think so, Your Honor. If I am at a political protest in which I am expressing my grievances against law enforcement, and then I'm later arrested for drunk driving and charged with resisting arrest, should the prosecution be able to use the fact that I was at a anti-police protest 3 months ago to show my intent in resisting arrest?
Well, let's use a different example. I'm at the protest and I say, I hate Governor Whitmer. 4 months down the road, I'm with Governor Whitmer, open carry, and she's shot. And I say it's accidental. And other people say, no, he did it on purpose. Isn't that prior lawful statement admissible to establish intent?
Yes, Your Honor.
Okay, that was the point I was trying to make. Okay.
Right. So now a decision is made to charge Mr. Musico with crimes after this 11-month investigation. First thing he's charged with, making a terrorist threat. It appears that all parties involved have quoted the Olentowski case. As Mr. Kirkpatrick correctly stated, the ruling in Olentowski was that in order to comply with the First Amendment, it's not just that a threat be made, but the threat be made in a manner in which to incite some sort of negative reaction upon other people or society at large, is what the court is saying.
Let me rephrase it a different way. That is intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. Would you agree with that?
That's correct, Your Honor. And that didn't happen in this case.
I'm quoting from page 9 of Mr. Patrick's brief, which is part of the Olentowski case. Go ahead.
All the statements made were made to like-minded individuals and to individuals that they thought were like-minded. Unlike that case where the statements made to someone in a different state, and more importantly, to add on to that, Your Honor, they've asked this court to treat these people as co-defendants, as all one person under the law. So we even have to decide whether or not a threat was even communicated to any other person, because they've told you, Your Honor, treat all three of these people as if they're the same. So now we have a guy in an empty room yelling his displeasure at the government. So no threat was communicated. Yeah, I also quoted the Thames case And, you know, the reason for quote the Thames case, even though it was a 1983 action, was they talked about in which when Thames won, you know, against the allegations presented against them and sued, said, well, wait a minute, we want to give, you know, officers the ability to act quickly and give them the benefit of the doubt. That was a case in which the officers had to make a quick second decision on whether to arrest that defendant after statements were made about an abortion clinic blowing up. Here, there is an 11-month investigation. Based on the testimony, we know that there was a statement allegedly made by Mr. Musico about firebombing a state trooper's home. It's reasonable to know that that wasn't true. There was a statement made about C4. There was, you know, and although the agent said, hey, I don't know if that was true or not in terms of firebombing, we know that the court can conclude that Mr. Musico was not telling the truth about firebombing the state trooper's home. There was a statement about the C4. The agent admitted that he found that the C4 was fake. There were all kinds of statements made by Mr. Musico, who they nicknamed Crazy Pete, weren't true. So unlike these other cases, on Ostowski, where I believe the arrest was made in a matter of days, or Thames, where the arrest was made right then and there, they had 11 months to know Mr. Musico wasn't engaging in any true threats. Not only was he not communicating these statements to anybody outside the group, they weren't true, he didn't mean them, they were just political hyperbole. Mr. Musico didn't make any threats about kidnapping the governor. You know, and now that the court has denied the hearsay motion, the court can't, you know, is going to impute unto Mr. Musico the statements made by other people. Your Honor, you still have to reconcile binding this case over with the Quigley case. Now, I noticed in the people's brief, they don't address the Quigley case. Page 15 to 17 of their brief, they talk about, you know, their personal opinion about the statute, and they say, I rely too much on this term kidnapping, but it's not my reliance. It's the Court of Appeals in Quigley, in which the people in that case conceded that when Mr. Quigley walked into City Hall with a weapon, mad because the police wouldn't investigate a kidnapping that he thought had occurred, and held the mayor's secretary hostage because Michigan decided they wanted to have this special kidnapping statute, that Michigan's kidnapping statute was not a violent felony for purposes of, you know, this act of terrorism. And they even, and I believe I provided the case to the court, they even analyzed false imprisonment and ruled the same thing, false imprisonment. Said, no, that's not a violent felony for the purposes of an act of terrorism. So if what Mr. Quigley actually did, although he was convicted of other crimes, wasn't terrorism, then how can what other people plan to do that never occurred be terrorism? And so in the people's brief, they don't say, well, Quigley is no longer good law, it was overruled. They don't say that. They don't say, oh, the facts of Quigley don't apply here because it's clearly on point. They chose to ignore it. You can't do that. The court has to address Quigley before binding over.
Your take on Quigley is it says false imprisonment is not a violent felony?
Yes, sir. Secondly, we get into this gang statute. People have to show, and again, I don't want to repeat things that Mr. Somberg said, that there were 5 or more people in constant contact. Mr. Somberg has already went over the testimony, you know, citing the testimony about Joe being MIA, Pete being gone. Mr. Kirkpatrick's already talked about his client leaving in late July. There was testimony that Mr. Musico left in the beginning of July. So who are the 5 people that are in constant communication while you are in this alleged material support of terrorism? There was no agreement by those 5 to commit a felony. And you can look at the habit and routine practices of the Wolverine Watchmen. It was to go to political protests and engage in lawful First Amendment activity.
That sounds like a character argument that you said is improper relative to the confidential informant.
What was improper for the FBI agent is not improper for me, huh? In argument, when they went to the Black Lives Matter protest, going to page 100 of the transcript, and we went over this with the we went over this with the special agent implement, and ultimately we got to empower. I'm sorry, y'all. Starting at page 9, going all the way down to 102. His last answer. Now they can't be present. Excuse me, not now. They can't be present at the protest as malicious to infringe upon the freedom of speech of those present, and they also can't enforce the law. Now, in this case, they didn't enforce those laws. Their stated purpose was to enforce the laws when they were, whether that's illegal or whether that's offensive or defensive. It's hard to say. So the very first one, the agent isn't even prepared to say that they did anything illegal. The other protests, as the court has already indicated, were lawful. Now, whether there were things said that made at those protests that the court wants to take to establish intent down the road, we can get to that down the road. But the Wolverine Watchmen, when they went to all these protests, even though the Black Lives Matter protests that turned violent, never engaged in any criminal activity. Secondly, in addressing the gang statute, you talk about whether or not the Wolverine Watchmen was a gang, and if so, if there were subsets of that gang. And that was the purpose of the Bemis case, Your Honor, in which the court there held that there can be a gang and there can be subsets of a gang. And in that case, the defendant was found to be both a member of the gang and the subset groups that engaged in the murder. Here, even if the court finds that Mr. Musico was a member of the Wolverine Watchmen and the Wolverine Watchmen was a gang, then clearly the QRF, firefighter, the council, leadership, FAFO, and then FREMA were all subsets of that gang. And Mr. Musico, not only was he not a member of those subsets, he was specifically excluded. And lastly, did Mr. Musico's membership of the gang, in the gang, provide any motive, means, or opportunity for anybody in that gang to commit a felony? No. Everybody already had their political beliefs, their social beliefs, their beliefs about guns before they joined this group. This is not a situation where a blood shoots a Crip that he doesn't even know merely because he's a Crip and I'm a blood. Everybody already owned their own rifles. Everybody already owned their own ammunition. There was nothing that the Wolverine Watchmen provided by way of motive, means, or opportunity to anybody else. Based on that, we asked the court to also dismiss that count. And as all defense counsel have already stated, material support of terrorism, we are likewise asking the court to dismiss that. And this charge is even unique, Jan. I understand the people didn't even address this in their brief, their written brief. I think there's an agreement between defense counsel that there are no notes of decision or appellate cases that control. So there's nothing to argue in terms of whether or not the court abuses its discretion in this case. As a matter of fact, there's no standard jury instruction. I wrote my own. I couldn't even find any evidence that this charge had ever been litigated in any trial court in the state of Michigan. So the first we have to do is we have to look at whether what the jury instruction should be and what the prosecutor has to show by way of elements by probable cause. And I think Mr. Somberg has already done a great job eliciting that and arguing it to the court, so I'm not gonna go back over that. But what I will do to add on to what he said is, as I did in my brief, the first thing we have to do is we have to define material. And so because material isn't defined in the statute, we use the common definition. And that's what I did in my brief, that it must be important, essential, and relevant. There is nothing that Mr. Musico did that was important, essential, or relevant to any plot or support of terrorism. He didn't own any home. He didn't provide any training space at all. whether it was for a terrorism plot or just regular training. He lived at the Munich Road address. People came to Munich Road to train. There was a litany of cross-examination between me and the special agent as to whether or not Mr. Musico had actually invited anybody. His response was always, well, it was discussed, and he was a great part of that discussion, but he didn't invite anybody, Your Honor. And more importantly, he didn't have the ability to tell anybody else not to come. He didn't provide any training. That was discussed in cross-examination with the special agent. He didn't have any skill set, any military skill set. He never served. He had no combat experience. As a matter of fact, going to, I believe, 105 and 106 of the transcript, 105 started at like line 15 down to 106, I specifically asked the agent, Mr. Musico didn't train anybody. Said no. He was there being trained by other people, including your confidential human source. Said yes. He had no military training, had no combat skills. He was there as a rank and file member being trained. And Jan, I think it's important to note that the people at that training who wound up in Luther with Mr. Fox and training for the plot that was to kidnap the governor, as Mr. Kirkpatrick stated, were the ones that had prior military experience, both Dan and Ty Garber. So clearly, Mr. Fox, when he came, was able to see who at the Wolverine Watchmen was good and who was serious and took those people. It wasn't Mr. Musico. He didn't give him any money. He didn't help finalize any plan. And as was stated in the testimony, in early July, he left. He went to Alabama. Now, the court can go all through the transcript to see when he came back. There's no testimony about when he came back. Now, there was testimony that at some point, and it's indicated on the people's attachment to the brief, that he contacts Barry Croft and says, hey, bring up the 3 plan. And what does Barry Croft say? He said, Pete's a good man. I've leaned on him for spiritual support during these tough times. He completely dismisses him. That's no different than when I'm down at Ford Field watching the Lions game and I'm yelling at the coach, run a different play, and he ignores me. Okay, that don't make me a member of the coaching staff. Any of the coaching staffs have been fired. It just means that I'm there and I'm yelling something that's not acceptable. And that's all Mr. Musico did during this time period. He never led any training. He never provided any place to train, any weapons to train. He never gave anybody any particular skill set or tool to use in what was ultimately the terrorism plot that we're here for. No car, didn't drive anybody, no gas money, didn't even make lunch. There was no material support given by Mr. Musico to the individuals who went on to become terrorists, Your Honor. And based on that, we'd ask that count be dismissed, Your Honor. Do you have any questions for me, Your Honor? No? All right, thank you very much.
Judge, I'm just going to make a couple of points of law here to start off with. Okay, so first, we don't have to make up any definitions in this case. All the definitions are in the statute. And in fact, there is case law on this charge that is unpublished. So there's plenty of that. First, get that out of the way. That's the providing material support as well as communication of a terrorist attack. So there's a lot of unpublished case law on that. Second, the definitions are in the statute. And they are listed, Judge, and these are very important definitions because they define what material support is. They list out several things. They define exactly what a gang is. So the definition section I'm talking about, the Michigan Anti-Terrorism Statute, is 750.543B. So just a couple of things on that. So first, the gang statute, as Attorney for Mr. Morrison mentioned to you, Judge, that the gang statute is 750.411U, and in subsection 1A, it says that gang means an ongoing organization, association, or group of 5 or more people other than a nonprofit organization. So what I have to show is that it is not a nonprofit organization. And being lawyers, we all know what a nonprofit organization means, and it has to be registered by the state. So what I have to prove, I have proven, which is there is an exemption here in this group of 5 or more people for other than a nonprofit organization. And the agent clearly testified, this is not a nonprofit organization registered in the state of Michigan. Okay, so second judge, we've made a lot of reference to the Osentowski case. And on page 605, there is a section here that talks about true threats and what they encompass, right? Speaker means to communicate a serious expression of intent to commit an act of unlawful violence to a particular individual or group of individuals. The court goes on to say in that paragraph, accordingly, the only intent that the prosecution had the burden to prove was defendant's general intent to communicate a true threat. So a general intent to communicate a true threat. And so we're talking about the act of communication. We're not talking about what the definition of terrorism is. We're talking about communicating a terroristic threat. What is a terroristic threat? That's what's defined in the statute in 750.543M and in the related definitions section. And an act of terrorism is a violent felony, dangerous to human life, intended to intimidate or coerce a civilian population or influence the conduct of government or a unit of government through intimidation or coercion. So that definition that we've been throwing around here, Judge, is actually just the definition of terrorism. It's not the definition of communicating an act of terrorism, which the court in Osentowski says that there has to only be, the prosecution only has the burden to prove the defendant's general intent to communicate a true threat. So I want to get that off the table here first. And Judge, also, the statute does not give an exception for friends, dinner party guests, buddies, ideologically like-minded individuals. There is no exception for that. And there is no requirement under the statute, and I keep hearing this, but it's not in the statute, Judge, of bringing fear is not part of the statute. The onus here is not on the victim, according to the statute, Judge. The onus is on the speaker, the person that is communicating the threat. And right there, written in the statute, Judge, it says, and the legislature thought of this when they wrote this statute, it says you don't have to intend to carry it out. You don't have to have the capability to carry it out. You just got to communicate it. And the legislature already thought of that. So if no one knows, it's not a threat. That's what I heard a couple of times. Yeah, that's right. If no one knows, it's not being communicated. So yeah, it's not a threat if no one knows. And the exhibits that we entered into evidence shows that people know. For this court not to bind over on the threat, communicating a threat of terrorism, Judge, would require that you didn't find that the people in the group are persons. It would require that you find, Judge, that Dan, the CI, is not a person that threat was communicated to. And if you look at the exhibits we entered into evidence, it goes beyond just the closed group or 1 or 2 individuals. Exhibit 4N with Mr. Morrison. 1, 2, I'm coming for you. 3, 4, better lock your door at GE Whitmer. Hashtag Boogaloo, hashtag Boojahadeen. This is on Instagram, I believe, was the mode of communication. So this is to everyone that follows him on Instagram.
So
Mr. Morrison,
you think those photographs, no matter how distasteful, are not covered by the First Amendment?
well, Judge, that's a question of fact on whether he's serious, and it's a question of fact on whether that it's a question of fact as to that, Judge. It is certainly a question of fact, and it's for a trier of fact. And for this court to make that determination would be wrong. And not only that, Judge, and for H, Mr. Morrison, if you pussies want to do shit, join us or be complacent up to IDC, y'all were begging a few weeks ago for a shutdown. Now you're crying anyway. We want to restore the republic and true liberty. If you're about that life, come on over to Wolverine Watchmen and come train and get ready. If not, have fun bitching on Facebook. If you don't like my language, I'm sorry. I'm tired, mostly tired of y'all. I mean,
So
these are all things, Judge, that he is communicating not just to a closed group, as the court is citing, but rather to everyone.
So anytime someone publicly says something the prosecutor can't like or doesn't like, you can call it a false report or threat of terrorism
No,
and argue that it goes to trial?
no, Judge, no. It's not about what I like and don't like or find offensive or don't find offensive. It's about whether it satisfies the definition section of 750.543B. And it's not just this statement, Judge. It's every statement he made that communicated an intent to commit terrorism, which he not only said, Judge, but he went and did things in real life. This is more than just talk. We're talking about encrypted apps, training on offensive tactics, using homes and land to do so, spending your own money and time to go do these things. We're talking about traveling to the middle of nowhere. We're talking about your own time and resources. You're trying to combine with other groups. We're talking about refining and improving plans, giving direction to plans. We're talking about
I understand the distinction between encrypted communications. I'm just curious because I didn't realize it was going to go this broad. What public communications, whether it was on Instagram or Facebook, are you contending justifies a charge of false report or threat of terrorism?
No, Judge, the group posts, there are still members of the group. So if the court is talking about a closed group, you're talking about vetted members of a closed group. But Judge, you have to find that none of those people are persons for purpose of the statute. You have to say that because you're in a group, that disqualifies you from the statute. But there's no exception for closed groups or friends or buddies or dinner partners or people that you recruit for your group. There's no exception for that.
What
They're
I'm
persons.
what I'm looking at is page 9 of Mr. Kirkpatrick's brief. It cites Ostentowski.
Yep.
100 or pages 109, and they talk. It talks about a threat may constitute an act of terrorism, and then it goes on to discuss acts of terrorism.
Mhm.
And down at the bottom, it says that is intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion.
Yes.
I understand what you say. I could read the statute as well as anyone, and it says any person. I understand that, but
Judge,
it looks
it
like.
doesn't say that here, Judge.
Okay.
It doesn't say that in this section. This is the definition of what terrorism is.
Okay.
When you're talking, and I don't mean to, I'm sorry.
No, that's
to interrupt you,
okay.
Judge. This is the definition of what terrorism is. If you look at the statute that we charged, which is the one right above it, the paragraph above that paragraph, Judge, that outlines the communication requirements. What you're defining, judges, is the definition section of the terrorism statute.
And isn't false report or threat of terrorism under that section?
Yes, Judge.
And doesn't your complaint say did threaten to commit an act of terrorism? So don't I have to refer to the definition of terrorism?
You do.
Okay. And isn't Mr. Kirkpatrick citing Ostentowski relative to what constitutes an act of terrorism?
Yes, Judge.
Okay, so I
just want to make the distinction really clear that when we're defining an act of terrorism, we also have to talk about what the statute says about communicating.
I understand, but
Okay.
you've charged, your complaint says did threaten to commit an act of terrorism. So I'm just saying, what is an act of terrorism? And I perceive that Mr. Kirkpatrick has provided us with that definition, which talks about coercing a civilian population. Are we all in agreement on that?
Yes.
Okay. And how do you intend to intimidate or coerce a civilian population when you're preaching to the choir, when you clearly believe that it's not going to leave your closed echo chamber.
Not everyone in the choir is part of the choir though, Judge.
Okay, but we're talking about intention. As far as these three folks go, Dan was their number two. They believed Dan to be part of their group. So I guess I'm not accepting your position. Well,
I understand, Judge.
since he's a confidential informant, it still gets to the intent of these three defendants. And as far as these three defendants were concerned, Dan was with them. Dan isn't going to tell anyone, and end of story.
Right, Judge, except that Dan's not the only person in the group, right?
Okay, well, who else is in the
And
group?
what you're saying though, Judge, too, is that if you find that communicating that to Dan means that Dan's not a person for purposes of the statute. And that's what I'm pushing
Well,
back against.
yeah,
Judge.
but the statute also says, that you have to communicate a threat of terrorism, so you can't ignore the definition of terrorism.
Right, you can't ignore the definition of terrorism.
Yeah, and
I think we're saying the same thing.
I think we're saying the same thing. You want to deal with any person, and I'm saying that your complaint does not fall, or what you're alleging is not an act of terrorism.
Right, and I think that's where where we also differ though,
Yeah.
Judge, in the sense that when you communicate that you're going to go and commit violence against a politician, that is always an act of terrorism. When you communicate that you are going to do anything that is using force, dangerous to human life, intending to coerce or intimidate a civilian population, you're not trying to coerce or intimidate Dan, Judge. You're trying to say that you are going to do an act that is all of those things. It's not Dan as your intended target, it's government as your intended target. Anything that affects the conduct of government or intimidates a particular group or civilian population.
Boy, your interpretation really screws up the definition of threat as everyone else understands it to be.
I think I'm keeping with the law,
It
Judge.
reminds me of Dr. Strangelove, the doomsday machine. And Dr. Strangelove, the Russians have the doomsday machine and they want it to serve as a deterrent. And Dr. Strangelove says, well, in order for it to be a deterrent, you got to tell someone. It's not a direct analogy, but I think it's the same thing.
I think we differ, Judge.
Okay.
I think
Okay.
I'm staying true to the statute.
Okay.
All right. Just a couple more things here. I know that this seems to be going towards the direction of this is Dan. This is all Dan's fault. Dan directed this whole thing. This is some sort of FBI plot, and my guys just, got spun up in it. But there's a lot of things that the testimony revealed that Dan didn't do. He didn't form the group. That was Mr. Morrison. He didn't ask people to download apps so they could look for law enforcement officers' addresses. That was Mr. Musico. He didn't organize, he didn't organize the itineraries. That was Mr. Bellar. Mr. Bellar did in fact participate in trainings and teaching other people. He worked at a gun range and had a lot of experience with guns. He didn't request any QRFs to be deployed. That was Mr. Bellar. He didn't suggest kidnapping. That was Mr. Musico. He didn't come up with code words. That was Mr. Bellar's initiative. He didn't teach anyone how to pack gunshot wounds in case people got into firefights. That was Mr. Bellar. He didn't try to provoke law enforcement at protests. That was Mr. Musico and Mr. Bellar. He didn't reach out to national contacts and try to combine forces. I can see where this is going as far as directing, but I think there's been plenty of evidence here, especially just to establish a question of fact, Judge, to bind over on all of these charges, as well as the additional charge that we're asking for.
What's your position on the kidnapping and false imprisonment issue raised by Mr. Johnson?
I mean, my position is what is exactly in the statute, which is keeping right to the statute, and that's 750.543B definition section, where it defines what a violent felony is. And it says violent felony means a felony in which an element is the use, attempted use, or threatened use of physical force against an individual. There's no requirement there be a kidnapping or an unlawful, imprisonment, or the use, attempted use, or threatened use of harmful biological substances, biological devices, chemical substances, chemical devices. So violent felony is actually a much broader, it's a much broader definition according to the statute than what you and I are used to in a criminal court of law, judge, of what a violent felony means. All it means is a use or threatened use of physical force against an individual. And that's 750.543B(H).
Didn't Quigley address that statute?
And what did it say? That unlawful imprisonment isn't a threatened use of force or attempted use of force?
That's exactly what they said.
Well,
They pulled the jury instruction for unlawful imprisonment and kidnapping and said Michigan decided to have these special kidnapping and unlawful imprisonment statutes that do not require violence. Therefore, it doesn't fit the definition of violent felony for terrorism. And in that case, Your Honor, the people conceded.
That is
When they
not
get to-
what Quigley says, Judge. If we want to bring it up, we can do that. Happy to provide it to the
I would
court.
rather just have the oral argument.
Thank you, Judge.
And I'm sorry, I thought I provided the case to the court.
Yes, I reviewed it.
All right.
That's all I have, Judge. Thank you.
As an initial observation, don't necessarily require that the criminals be extremely competent or overly organized. Standard of proof at this stage is the prosecutor must present evidence sufficient to make a person of ordinary caution and prudence conscientiously entertain a reasonable belief of the defendant's guilt. It's nowhere near proof beyond a reasonable doubt. I think it's important to reiterate that lawful activities in and of themselves can be used to glean or determine intent as it relates to subsequent criminal acts. From the defendant's posture, and I would expect this to be the case because we're in an adversarial system. The defendants choose to isolate particular incidents and indicate it's not against the law. I think that is an effective strategy. It may have jury appeal. I also believe that, contrary to some of the assertions, we do not need the ultimate crime to be committed. Whether it's killing, kidnapping, or whatever, for there to be culpability under the current charges. In terms of hearing, the lengthy testimony, it's certainly by far the longest preliminary examination I've had in terms of hours of testimony. I found the informant to be extremely credible. He is a severely injured veteran. I would also note that as informants go, he's usually not the type of informant that this court sees. Usually, the informants that this court sees are criminals themselves seeking to avoid charges, or in the alternative, seeking a sentence reduction. In this particular situation, we have an informant that actually wanted to join the Watchmen based on an algorithm that directed him to that site, because in some regards he was politically aligned with their beliefs. The FBI didn't go out looking for him. Rather, the informant went to the police after he was deeply disturbed by a number of things, but I think the tenor of his testimony were the comments made by Mr. Musico about tracking down the addresses of the police and perhaps engaging in some type of reverse red flag action. He goes to the police because he's afraid that there may be violent intent here. And, you know, that perception in and of itself is very relevant. A potentially sympathetic character that to the Wolverine Watchman makes a determination. I don't like what I'm hearing. I think I better report it to the police. Police contact the FBI. The FBI then contacts Dan. He decides to become an informant. And in the process, full well knowing that to a certain extent, he's screwing up his personal life. Another preliminary observation is that the defendants are joined at the hip here. The prosecution did a very good job, albeit lengthy, in establishing who knew what and when. However, at the preliminary examination and in fact at trial, you don't have to leave common sense at the courthouse door. You can make reasonable inferences in terms of who knew what. In a snapshot of time in 6 months, these folks saw each other a whole lot more than I've seen many of my relatives in my 65 years. I mean, they were together a lot, not only in person, but on their encrypted network or networks. Yes, I'll go to the charge. It really causes me difficulties. Count 1. Did threaten to commit an act of terrorism and did communicate that threat to another person. Court's ruling that we need to go to the definition of terrorism. And if we consider the definition of terrorism, we get the interpretation under Ostentowski. And we've beaten this issue into the ground. I'm going to use my own words. The threat must be done with an intent to create mayhem. I understand that's not the definition. I like that word better. And in that regard, yes, it can be communicated to any person, but it still needs to be a threat of terrorism. And if you're saying stuff in a closed environment, in many respects, it's no different than just thinking the thought to yourself. It's not going to be blabbed to the outside world. So yes, we have repeated statements by all these fellas about killing people and doing things of that nature all throughout April on and at various times. I'm not minimizing any of the defendants or their cohorts. They're all people. I understand that. But the person must be receiving a threat of terrorism. And under Ostentowski, if it's not going to get out to the public, how can one take the position that it is designed to create mayhem? I know the Attorney General disagrees on this issue, and I'm certain that this won't be the last word on it. But nevertheless, the Attorney General has indicated, well, one of the individuals was an informant. And I suspect that the Attorney General was asking questions about, well, did you call the police? What was your reaction at the one of the protests at the Senate or at the legislative building in Lansing? I believe the confidential informant notified the police. I know that with the Home Depot issue, the police were notified. And in that regard, if one or more of the defendants had yelled it out to the general public and the general public had heard it and then called the police, that would be different. But there has to be some form of intent here to incite mayhem. And even if you voice it to Dan, the informant, all three of the defendants, individually and collectively, clearly believe that Dan was with them and wouldn't say anything. So yes, they're talking to a person, but they're not communicating an act of terrorism as defined by Ostentowski. I'm going to dismiss count one. In terms of Mr. Morrison, there's an argument that he had disengaged. In terms of Mr. Musico, there's a contention that he's crazy Pete and no one listens to him. In terms of Mr. Bellar, he takes the position that he was long gone before the plot to kidnap the governor was finalized. I think if one analyzes the facts, and I don't know, 700-800 pages of testimony, these individuals were a whole lot more involved with the Wolverine Watchmen organization than what they claim. In terms of Mr. Morrison, there's absolutely no question that he's the #1 man. Is he taking or making the contention that as the #1 man, he's oblivious and totally cut off all communication with his organization when he was tending to his marital problems. All the practices were at Morrison's property. In fact, there was a shooting range at Morrison's property. He hosted on 2 occasions Adam Fox. He was the administrator of the web page with Mr. Bellar. And as administrator, they did basically an initial vetting to see who could get to the next step. The first step, apparently, I have the impression that it was a few questions that you would have to perhaps answer, and then if you answered them appropriately, you were referred to wire. And then on wire, you then basically underwent a process or interview, which was referred to as like a job interview. On June 20, in fact, his leadership role was codified in writing as the leader. The testimony indicated that even though Mr. Morrison didn't go to the Dublin, Ohio meeting, which was the initial, for lack of a better word, nationwide meeting of various organizations of like-minded thought, that he clearly knew what was going on there. Apparently, the reason that the Watchmen didn't go to that is that the time frame, apparently they were made aware of the meeting on relatively short notice. The more significant meeting where the plan of terrorism was further honed down was in Peebles, Ohio. Mr. Morrison, along with Mr. Musico, were invited. Apparently, they didn't go. But Dan went. Ty Garbin went. Dan Harris went. I believe Caleb Franks went. They're all members of the Wolverine Watchmen. It defies belief to have that many members go and say, I didn't know anything about it. Going back to Adam Fox. In fact, he had dinner with Adam Fox early on in April. After that dinner, Adam Fox, along with his number 2, attend a Wolverine Watchman training. There has been some, I guess, disagreement or an attempt to distinguish or decipher who invited Fox to the training, but it's Mr. Morrison's property. He wouldn't have come to that training if Mr. Morrison didn't want him there. In terms of Mr. Musico, It appears that he appreciated the national exposure of the protest. But by virtue of his relationship with Mr. Morrison is his son-in-law. They live on the same property. That in and of itself gives him some cachet that perhaps other members would not have. It is possible that Mr. Musico is a legend in his own mind. That's something for the jury to decide. Mr. Musico, I believe, claims that the 60 to 70% of the ideas came from him vis-a-vis the Watchmen. He certainly wasn't afraid to submit what I perceive to be extremely violent ideas. Catch and release. The 3 plan. Locating police officers' addresses with the ONX program. Testimony also reveals that Pete would address the weather or the Wolverine Watchmen before the meetings. If he was not a leader, at least informally, he wouldn't be addressing the Watchmen group like that. And at one point, he addressed the Watchmen and told people that were willing to attack politicians to leave. Once again, that is not something that a fellow traveler is going to say. That is someone that has enough clout to be given permission to speak like that to the rest of the group. The national leader of the militias or the organizations that were trying to get together was Barry Croft. He was in touch with Barry Croft through September. He's Barry Croft's spiritual advisor. And in fact, at the second Ohio meeting, he specifically asked Dan to take the 3 plan down to the national meeting. Granted, perhaps it is true that everyone would not believe him. But it's also possible that he's clever like a fox. The jury's going to get to decide. I'd also note that the Watchmen had no problem of kicking members out. They had a rather large purge at one point in time for the people that don't show up to training. And then secondarily, there were additional folks that left as a result of what Mr. Musico had indicated about politicians. Now, in terms of Mr. Bellar, he's one of the web pages, along with Joe Morrison. The testimony is that he, led trainings both at Munich and at the national training, 2-day training that took place in Wisconsin. Oh, Mr. Kirkpatrick rightly notes that it looks like we're dealing with some stated credentials, and that there were other people that could do it better. But there's no requirement of competency to potentially be responsible under the charges we're dealing with here today. Mr. Bellar, actually, unlike some of the other defendants, I think was present at more significant hearings than anyone else when we compare with Musico and Morrison. He's involved in that rather strange meeting at the back shack. I almost wanted to laugh about that, but it's not laughable when you start discussing what they were talking about. It's a meeting with Mr. Fox. Once again, it's a meeting that doesn't take much of an inference to realize that Musico and Morrison knew about this, where they were discussing the sharing of resources. Apparently Fox is head of the 3 percenters. Apparently Fox at one point in time was going to form the Second Continental Army. Mr. Bellar also went to the national training in Wisconsin, as I indicated. He instructed there. A number of Wolverine Watchmen went to that training. Adam Fox was there. Barry Croft was there. The Wolverine Watchmen charter, for lack of a better word, talked about forming QRFs. Mr. Bellar formed his own QRF. And in fact, it was essentially his QRF, which ultimately went to Adam Fox when a decision was made as to what was going to be done. Curiously, there was a second training in Luther, Michigan, and as I read the transcripts, it was Mr. Bellar who instigated that invitation, or at least early on. I would note with Mr. Bellar that once there need to be certain prerequisites. So once the material support is provided, it doesn't matter what he does then. That's how the court interprets that statute. Mr. Bellar apparently had a problem with Mr. Morrison when he brought a girlfriend to a training. Every organization is going to have its ups and downs, its disagreements. That's not surprising. My interpretation of the facts is the only reason he left the state were money issues.
one point, I think he didn't have enough money to pay the rent because he bought armor. At another point, there's a reference to damage to a motor vehicle. But it was lack of money which sent Mr. Bellar to South Carolina, not a cessation of his involvement with the Wolverine Watchmen. And finally, after he left, the authorities searched Mr. Bellar's former residence and obtained some interesting materials. Mr. Bellar contacts the Wolverine Watchmen, lets them know of the situation so they can take remedial measures. If he is disengaged from the Watchmen, that call would never have occurred. So to the extent that maybe a member is crazy or they have disengaged from the Wolverine Watchmen as it relates to all three of them, there was no total disengagement, and no one is totally crazy or not listened to some degree or another. By analogy, I think these gentlemen are at the top of a mountain. Make a snowball, start rolling it down the hill, and at various times, maybe their effort diminishes or they leave temporarily. But they started a very big snowball, which wasn't going to stop. The gang charge more than 5 people. Clearly satisfied. In order to be a gang, there also has to be a unifying mark, manner, protocol, or method of expressing membership, including a common name, sign, or symbol, means of recognition, geographical or territorial sites, or boundary or location. I think that portion of the requirement is met if you consider the following. They have an identifiable name as Wolverine Watchmen. In fact, Wolverine, I still think, is the state animal. Clearly located in Michigan, as opposed to other multi-state organizations. There are also other Michigan organizations, but they have a specific base of location where they do most of their stuff. That would be UNIT. They have a multi-tiered vetting process. Secret means of communication on encrypted networks, including but not limited to wire. They had required trainings that one must attend. They were very exclusive in their membership with the purges. Repeated use of the Hawaiian Boogaloo theme in terms of postings and clothing. Certainly the out-of-state people perceived them to be a Michigan organization. They had a typical attire
at public protest, more specifically, the carrying of firearms and pretty much looking like someone ready for combat. We had a membership criteria, which I think kind of goes through the vetting process and the interview. Although the leadership was not formalized, I don't think there was any doubt that Joe Morrison was the head guy. Later, leadership was codified, I think, in June 20. Joe's the head guy. Informant number 2. We've got Sergeants Bellar, Garvin, and Harris. I also think that for purposes of preliminary examination, there's no question that the Wolverine Watchmen, this gang, was not a not-for-profit organization. And are they responsible under the gang membership statute? In order to do that, the people need to prove that there was an attempt, or they did commit the felony of providing material support for acts of terrorism, which I will get into now. I am engaged in some degree of fact finding here. And the first thing that sticks in my mind is, why all of the secrecy? These 3 defendants were not shrinking violets. They were not afraid to publicly protest, exercise their First Amendment right, and in Mr. Musico's situation, in a very aggressive manner at one protest. If they have no problems with being very public with their positions, why totally disappear? One could say, well, they're paranoid and they want to be left alone. I guess that's one conclusion. Or another conclusion could be is they're doing stuff they know they shouldn't be doing and they don't want anyone to know about it. The second thing that stuck in my mind was, why do all this work? Why do all this training of a varied nature? Why travel to all these places? Why spend all this time texting each other? Do you mean to say it means nothing? I'm going to expend this amount of time on anything. I'm going to have an end goal in mind. And I do believe it's something more than a social club that wants to exercise its right as some type of constitutionally protected militia. Pretty much from day one, it's clear that the members of the Wolverine Watchmen believed in the Boogaloo, believed in civil war, believed it was coming. And I don't have to go through the pages to support the proposition that the defendants individually and collectively wanted to precipitate the violence associated with Boogaloo. I got tired of making notes. I don't believe it's fatal to the material support charge that a plan wasn't finalized. I don't think it's fatal to the existence of a conspiracy that a plan wasn't finalized. It's manifestly clear to me that the Wolverine Watchmen very quickly decided to implement or precipitate the civil war as dictated by the general doctrine of Boogaloo. Sure, they may have floundered a bit, but that's something that always happens when people embark on a rather large project. But the intent is so clear that these individuals were going to do something more than spout off threats to each other. There were a variety of plans. I have to use the word plan in a, I guess, rather expansive interpretation, but a plan nonetheless. Even something stupid can be a plan. And at one of the protests that I believe Adam Fox was there, well, there were a lot of statements made about wanting to start the Boog. Discussions of, do we have enough people or not? Musico floated his plans. That second meeting in Ohio was for purposes of finalizing plans so that nationally it would be determined what was going to be done first, which state was going to be hit. How did the Wolverine Watchmen contribute to the ultimate plan, which was eventually honed down to allegedly kidnapping the governor, although I don't perceive that, given the nature of these organizations, that is what was going to actually happen. Because of the loose nature of how all these groups approach this. I don't mean to get too esoteric, but I would, as an observation, I would say, for those that ultimately joined Adam Fox, if there wasn't the Wolverine Watchmen, I have serious questions whether they would ever hooked up with Adam Fox and or Barry Croft. Wolverine Watchmen, to some degree, provided them with the platform that allowed the contacts. Joe Morrison was known to have national contacts. The secret vetting also played a role. There seemed to be an undertone of, if you're not with us, you're against us. People were kicked out. People were asked to leave. What do you have left? An echo chamber. The Wolverine Watchmen created an echo chamber which reinforced and perhaps hardened the beliefs of the remaining Watchmen. This is an interpretation and opinion I would note. It's based on what I perceive to be a logical inference. An inference that I think is warranted, dating back to 2011, and the various forms of jihad that we have seen since then. And I don't think it requires an expert to draw some type of conclusion in that regard. From a legal standpoint, one can observe it readily. Some people watch only one news network, and some people only watch the other news network. It reinforces their beliefs. What I've said thus far is really intended to be more contextual than anything else. But the repetitive, offensive training that these individuals undertook, granted, it may not have been as efficient as maybe some other people would have run it. But this training certainly had an impact on these Boogaloo soldiers. Kill houses, convoy intersection, breaching doors, live fire, crawling on the ground, dressing up like stormtroopers, obtaining equipment, obviously. This improved their ability to participate in violence, which each of the three defendants mouthed in various forms. So we have a whole lot of training, increasing expertise with the Wolverine Watchmen, winnowing down their membership to only include the true believers. And while all of this is happening, the Wolverine Watchmen then are taking steps to combine with other militias. Adam Fox, located in Michigan, multiple meetings with him. He's at 2 trainings. His contact with Adam Fox may very well have undoubtedly resulted in his attendance, along with Barry Croft, at the National Wisconsin training, which a slew of Wolverine Watchmen attended. And at that session, I believe Adam Croft and Adam Fox commended the Wolverine Watchmen for their teamwork. A member of the Wolverine Watchmen invites the people in Wisconsin to come to a Luther, Michigan national training. And at yet another training, it's where Adam Fox picks quite a few Wolverine Watchmen to be part of his team to participate in what was labeled as a kidnapping of Governor Gretchen Whitmer. Ty Garvin, Caleb Franks, Dan Harris, and I think there was a fourth, maybe Brandon Caserta. Most if not all of those folks, by the way, were from the QRF that Mr. Bellar headed up. Put it in simple words, the way this shook out, it appears the Wolverine Watchmen, to use a baseball analogy, was the AAA ball club for the major league team, the farm club. Train, correct any deficiencies, and send them up to the big leagues. Unfortunately, the big leagues was something extremely heinous and illegal. Now, there has been some discussion of gangs and sub-gangs. There's absolutely no proof that any of these Wolverine Watchmen that eventually went to Adam Fox ever quit the Wolverine Watchmen. There is absolutely no testimony that the Wolverine Watchmen totally relinquished control over any quick reaction force. In fact, the quick reaction forces were envisioned, I believe, as part of the Wolverine Charter. The QRFs were designed to assist any Wolverine Watchman. I don't see the QRFs in relation to the Wolverine Watchman hierarchy any differently than I would view a gang in downtown Detroit that's involved in drugs. Part of the gang buys the drugs. Part of the gang sells the drugs. You have your enforcer, and you probably have the executive committee that don't do anything. No different. There's also been some questions whether this was a violent act. Discussion of kidnapping, discussion of false imprisonment. All throughout this case, there have been various threats or various comments made about Gretchen Whitmer by those inside and outside the Wolverine Watchmen. I think at one of the protests, when the Watchmen were kind of preparing to breach the doors, not knowing that the doors were open, and not appreciating the fact that they were extended their full rights under the First and Second Amendment. I don't see it as so much as a defense of the defendants as a pat on the back towards our system of government. But when they were posing apparently in front of the governor's door, which wasn't her door, at some point in time, I think there was talk about encountering the governor, and I think Mr. Musico said something about dragging the bitch out back. Within the Watchman organization, and perhaps this is where it's difficult to recall so much testimony, and a jury doesn't have to give the basis for their findings. And perhaps the outside co-conspirators as well. I don't think so, but within the Watchman community, there were multiple conversations about doing harm to Gretchen Whitmer, killing, hog-tying her. I think that came from Adam Fox. Displaying her on a table. I believe that came from Adam Fox. They wanted to kidnap her, to do surveillance on the house. That suggests to me that they're anticipating a home invasion first. There's also discussion of taking her to Wisconsin. There was also discussion of putting her out on Lake Michigan, which could easily result in her death. The point I'm trying to make, just because Adam Fox labels this a kidnapping, doesn't mean we're stuck with that label. As some of the defendants said, Adam Fox is crazy. I would contend that all of these people are not necessarily crazy, but perhaps erratic, which makes them the most dangerous of criminals because you can't predict them. The point I'm getting at is they may label it a kidnapping. As far as I'm concerned, going to Gretchen Whitmer's house and seizing her had a probable likelihood of resulting in injury or death to Governor Whitmer, or in the alternative, the commission of other violent crimes which fall within the statute. So in that regard, I don't even need to reach the issue of what label falls inside or outside the case of Quigley. For purposes of the record, the material support that these defendants provided to the terrorist Adam Fox is based on the defendant's role in connecting its members to Adam Fox and to the outstate individual Barry Croft. Providing extensive training to its members, and repeatedly exposing their expertise to others which resulted in a number of Michigan Watchmen being selected to join Adam Fox in their attempt to commit criminal actions against Gretchen Whitmer. In terms of the felony firearm, I do believe there's direct testimony indicating that all three individuals were using guns at the training. If the training is part of the material support, then you have the felony firearm. So each of the defendants are being bound over on terrorist act, providing material support, gang membership felonies, felony firearm, terroristic threats charged against Musico and Morrison are dismissed and I decline to add that charge as to Mr. Bellar. This case is assigned to Judge Wilson. Probably what will happen is the parties will be advised of a pretrial. It'll probably happen 4 to 6 weeks from now. I believe the procedure is to waive arraignment and have a pretrial. Mr. Bellar, I'm not going to have you wait. I had toyed with the idea of probably, of addressing your bond. And I want you to know that as the facts have shaken out, not as it relates to Gretchen Whitmer, but to the general public as a whole, your involvement and your potential propensity for violence is much higher than I had initially thought at the bond hearings. And I will specifically draw your attention to that Home Depot incident. Inexcusable. If you thought Fed Boy was a Fed, and you know what I'm talking about, the other member of the Wolverine Watchmen didn't even have to participate. You wouldn't even have to be there. But what do? Show up with a gun and say, if the cops show up, I'm going to shoot them. So in many respects, the 3 defendants, I think you may be the loosest cannon. We haven't had any problems thus far. You're certainly the youngest. You certainly don't have any money. And to a significant degree, I hope you're scared. You've been defanged. If I didn't think you were, we'd be adjusting that bond upwards. But I'm not going to do it.
Thank you, Your
Honor. From the Attorney General, I think we do need to get copies of the audio or any visual exhibits. I don't want to make Mr. Morrison's attorney do anything. There's that 20-minute radio or audio clip. If you could provide those in some form or fashion within the next 30 days, at least we will have it for the file, so that the circuit judge, if he wants to look at it, has it. Sometimes I don't run as tight a ship as I should, but every judge has their own style.
Happy to, Judge.
Okay. In terms of the arguments, the professionalism, outstanding. The representation, outstanding. Certainly is not the result. I know that the defendants wanted to a certain degree. I think it's not the result that the Attorney General wanted, but I do believe that everyone came prepared. I see why it took so long, but everyone I thought was very on point. I thank all of you. Thank you.
Thank you.
Thank you, Judge.
Thank you.
just very quickly, instead of asking a Republican or a Democrat, why don't you ask the people in charge of policing the border what the problem is? Rather than making a political statement and a question, why don't you walk right over there and ask the guy, what the hell happened? We got a chart, I'll give it to you. This was June, right here. See this spike? It was big. What did Trump do? He told Mexico, we're going to put tariffs on all your products unless you allow us to have asylum seekers stay in Mexico. What happened? It went down to a 45-year low because nobody's going to pay $20,000 to come to Mexico and wait for 4 years. The day the first plane load of kids went back to Central America, the unaccompanied minor problem went to a 45-year low. So why don't you do your job as a reporter and ask the professionals what the hell has happened in the last couple of months, and they will tell you. They told the Biden administration, if you do what you're planning, we're going to lose control of the border. They were right. I want to know who they told, and I want those people to be held accountable. I'm not going to give this up. I voted for every comprehensive immigration bill that's ever come out of the United States Senate. It is impossible for me to sit down with Dick Durbin and negotiate any solution to people already here, because if you legalize one person until you fix this problem, you're going to have a human tsunami. It will be another signal there, come to America, welcome. Don't ask us, we're politicians. Ask these people over here what has happened, why have they lost control of the border, and they will tell you.
Senator Cruz, I have a question for Senator Tillis and Senator Johnson about something really briefly.
Go for it.
Good. All right, Senator Johnson, Biden's transition team alleged the Trump admin delayed action on the migrant surge for months, even though it was warned about the problem from DHS and HHS. Johnson was the previous chair of the Senate Homeland Security Committee. Did he hear about this warning, and should Trump not assume some responsibility for the crisis?
I missed the first part of your question.
Sure. Biden's transition team alleged the Trump admin delayed action on the migrant surge for months, even though it was warned. So my question is, did he
Lindsay,
hear
give me
about
my
this-
graph.
Did he hear about this warning, and should Trump not assume some responsibility for the crisis?
Why don't you ask the people who did the briefing?
Yeah, so let me,
Why
first of
don't
all,
you ask
I
them?
really don't even understand the premise of your question. I've been working on this chart for a couple of years. It shows cause and effect. I will send it to all of your offices. And again, the fact of the matter is yes, there's a huge surge for a number of reasons. Deferred action on childhood arrivals. You had the Flores reinterpretation where it applied to not only unaccompanied children, but accompanied children. There are a number of things that caused this crisis, and then President Trump and his administration fixed the problem. That's the point we're trying to make. And rather than following those policies where we basically had this under control so we could take the next step, we were controlling the border, we could finish the fence. We were so close to taking that first step of having secure borders so we could address comprehensive immigration reform. Instead, President Biden ignored the advice of professionals, blew up all of these reforms, and now we've got this crisis, which is far worse today than it was even in 2019. We've had a day of over 6,000 people. 6,000 people. That's more than a caravan. That's a large caravan per day. How do you handle that? Put yourself in the men and women's shoes here that have to deal with this. How do you handle 6,000 people a day? Come on, it's a crisis.
Hold up a second. You can finish. Hold up.
Is it now time to pursue a more comprehensive? I know you're co-sponsoring the Secure and Protect Act. Do you think we should do a more comprehensive immigration reform?
Well, absolutely, but the table stakes are here. Exactly what Lindsay said. The reason that President Trump didn't have a crisis to the first question asked, created by a court decision, he fixed it. Well, we just had a meeting just last week with Democrat members. Lindsay and I were there and other members. And we said, if you want to talk about immigration reform, we're prepared to. We have a crisis at the border. We have to understand, again, listening to what the folks on the ground are telling us and making sure that we have policies that secure this border. You cannot possibly have a credible immigration reform proposal in Congress until you fix this crisis down here.
Thank you.
Thank you all.
runs, nearly 2/3 of all regions are affected by water restrictions. Farmers have seen their crops destroyed while others try to adapt to climate change. After two record-breaking heat waves.
Today, more than 70% of the Earth's fresh water is used for food production. Water has become the most coveted resource on the planet. To save humanity, the financial world has come up with a revolutionary idea. Wall Street wants to trade water as a commodity like oil or gold.
Water falls from the sky, therefore it should be free. Whenever I hear that, I always say, diamonds occur in nature and they're not free.
It's a financial product, like any other financial product.
The market is changing a bit over the last couple of weeks. It's around that $485 to $495 a megalitre mark today.
We're just at the beginning of this water financial revolution.
What about the guy that can't afford it? That guy still needs water.
The blue gold rush has begun. Can anyone stop it?
The human right to water means that it's not a charity, it's an issue of justice. This is the issue of our time. This is the crisis of our time.
With speculators pitted against protesters, the battle over the commodification of water has already begun. Who will come out on top? The planet, the people, or the markets? The City of London is a global financial hub. This is where the relationship between water and finance first began, 3 decades ago. Prime Minister Margaret Thatcher was seeking to revive the stagnant British economy with market-based reforms. Water was among the targets of her drive to privatize public services.